Hi, my name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're going to continue our video series designed to educate and inform the public, so please subscribe to our channel. You know, it's very, very understandable to most people that if they are getting divorced and they've accumulated stuff during their marriage, that the stuff has to be divided. Sometimes, though, depending on what the source of the assets or the stuff is, that is what could create a problem. For example, what about if you have heirlooms or special gifts that came to you from your grandfather, passed down to your father, coming back from your great-great-grandfather, and now you've got something special that's on the mantle. You're getting divorced. Do we divide that up too? Does the other side have a right to take it? So in situations like that, the court is going to look at that source, and even though you got it during the marriage, the court might well order that your family heirlooms go to you and yours go to you, and never the twain shall meet. And the court may very well, order that kind of resolution. Inheritance is similar in that the court might say, well, if she's inheriting money from her dad, that money should stay with her and should not be in consideration for the divorce settlement. However, and there is a big however to that, and as time goes on, people sometimes inherit money either from a parent or a relative or whatever. The question is what you did with it. If a person inherits something and always keeps it separate, there's a good argument to be made before the court that this is my inheritance. This was not something from my job. This is not part of the family income. I inherited this, and this should go with me as I depart in this divorce. Now, the court will normally go along with that, at least in theory, unless you've obviously gifted that thing to the marriage. So if you inherit $100,000 and it's an account and you leave it there, then you can argue, look, this is my inheritance and I've never done anything with it. It should remain intact. But if you took that money, put it in a joint account with your spouse, and then 5 years later decided that you want to get divorced, expect the court to say you have converted a personal asset into a marital asset, and now it's subject to division. Some assets are clearly in one category, some in another, some not so clear cut. If you have questions about yours, reach out and we'll be glad to help you out.